When your relationship has broken down, coming to an agreement about childcare can be very challenging. For example, you may not agree on who the children should live with, or how often you each spend time with your children. You may not agree on what school they should attend, or whether they should seek a certain type of medical treatment. Mediation and arbitration are usually the first steps you take in trying to resolve these family law disputes. But what if you try this and it doesn't work? Or these options are just not suitable in your circumstances? This can be the case where there is a history of domestic abuse in your relationship, for example. In this video, I will explain the different types of applications you can make to the court to assist you in resolving your issues around childcare disputes. However, it is important to remember that an application to the court is a last resort only. And throughout that process, the court will still generally try to encourage you to resolve these disputes between you so far as it can. The court can make orders in relation to who the children should live with or how often the children should spend time with you. These are considered child arrangements orders, as they simply set out arrangements in relation to your children. The court can also deal with applications that are specific to prohibiting a course of action or a change of circumstances. The most common is when parents don't agree to the removal of a child from this jurisdiction or to another city within the UK. If it isn't agreed, this can be prohibited. These are considered prohibited steps orders. In reverse, the court can also hear applications where you are specifically requesting this to happen. Whilst the most common is applications in relation to relocating to a different jurisdiction or a city within the UK, these can also be applications where you're requesting permission to send the children to a certain school, if it isn't agreed, or undergo specific medical treatment. These are called specific issue orders. For that reason, you're specifically asking something to happen. The court will consider both parents' views. It will also instruct a court-appointed social worker to ascertain the true wishes and feelings of the children. Their initial involvement is limited to a safeguarding check and some initial advice to the court. If the court then think it would be helpful for these social workers to provide a report to the court, then this is what they will do. They remain impartial from both parents and are solely a mechanism to guide the court to do what is best for the children. The court may also order external procedures or experts, such as psychologists or family therapy. This can either help the court in its decision making or assist the parents in their co-parenting, clearly as such with family therapy could do. These are usually privately funded, and the option to do so is usually brought by one parent. Of course, the court might not also deem it appropriate or necessary, but it is an option that can be considered during the process. In cases of severe domestic abuse allegations, the court may want to hear about this before determining the long-term arrangements for your children. This proceeds by way of a finding of fact hearing. This allows the court to decide whether these allegations are true on the balance of probabilities. However, this is only deemed appropriate and necessary in determining whether these allegations do affect the long-term well-being of your children and the ability of the parent to care for your children in light of these allegations. In most cases, this can cause further animosity between the parents, which can be difficult when the courts are always trying to encourage a healthy co-parenting relationship. Should you come to an agreement at any stage during the proceedings, this can be relayed to the court, and as long as they're happy with the agreement you have come to, their intervention can fall away. This is usually quite common, and a lot of parents find that once proceedings are live, that it allows them some structure with their discussions around the long-term arrangement with their children. As before, applying to court is the last resort. However, if you find that you're now in a situation where you're considering making the application to court, then please do get in touch and we can discuss these options in greater detail with you.